Well, how about student religious organizations? Who's the key vote there? Well, what would Justice Kennedy think? Is again the answer in the area of student religious organizations. We've had a couple of cases come down in that situation. Just to mention two of them there. One, a decision written by Justice Kennedy. Rosenberg versus University of Virginia. It's a 5-4 case. What Virginia did, university, was have a student fee. And that student fee then would be used to support student organizations and their publications. With one exception, and that is the student fees couldn't be used to promote a particular proselytizing religious message. Well, one group on campus, I think it's called Wide Awake Publications or something, wanted to produce a little brochure trying to convert people essentially to their evangelical Christian view. It was clearly proselytizing, nothing but come join our organization and this is what we'll do for you, and you should buy our message. And then sent the bill for $5,800 to the student organization that funds all of these programs. Right? Pay our bill for us, you're paying it for everybody else. And their argument was essentially you paid the bill for other groups that have controversial viewpoints. I mean, it's the Young Republican Club and they have a brochure, you pay for them, or the Young Socialist Group, you pay for them, or the Young Vegetarian Group, or whatever. You'll pay for their publication. You can't deny us our right to use this money, the student fees, for our purposes as well. That's viewpoint discrimination. And what's the outcome? 5-4, Justice Kennedy says, yeah, you're right about that. This is viewpoint discrimination. It's actually decided on a free speech ground, but he cites the Establishment Clause as well and says, but the key thing here is neutrality, right? A central lesson of our decisions is that a significant factor in upholding government programs in the face of an Establishment Clause attack is their neutrality towards religion. We've held that the guarantee of neutrality is respected, not offended, when the government following neutral criteria and even-handed policies. You can read that. The word neutral appears 4 times in that one paragraph. And even-handed another time. And then in the next paragraph it starts out, the government program here is neutral. Right? So what's the principle that's coming out of Justice Kennedy's opinions in these student organization cases? You got to be neutral. Yeah, and that means being neutral if somebody's promoting an avowedly religious message or they're promoting an avowedly political message or whatever message it is, you have to be neutral. You can't say no to a religious group and say yes to these other groups. That's where he's coming out of these cases. Neutrality is the key principle. 5-4, Rosenberg versus Virginia. The dissenters said, and they point out, here are tax dollars. Your tax dollars, my tax dollars that are being used to write a specific religious message, trying to convert people to a particular religious view. James Madison to be appalled. That was the 4 dissenters' view. Clear Establishment Clause violation. But Justice Kennedy saw it as neutrality. We're just being neutral here. Whatever your message is, doesn't matter. You're all entitled to the money. Next case up, Christian Legal Society versus Martinez, which is a case decided just this past year, again, 5-4, with Justice Kennedy being the swing vote. University of Hastings Law School out in California had a controversy. There was a student organization there, the Christian Legal Society, which wanted to be a registered student organization because if they were that, then they could hold their meetings in different student classrooms and get billboard usage and have other privileges that other registered student organizations had. However, they had a little problem, or at least a problem as far as the Hastings Law School thought, and that is that they said specifically that they would not accept as members, quote, students who have engaged in unrepentant homosexual conduct, unquote. If you've engaged in that unrepentant homosexual conduct, you cannot be a member. Hastings had a policy that essentially said, if you've got a student organization, you have to let everybody come. And an all-comers policy. Everybody has to be a member. And presumably, I guess this would mean, you'd have the Federalist Society would have to let wild-eyed liberals in, and the American Constitution Society would have to let hidebound conservatives in, and the Women's Caucus would have to let men in, and so on. But that was their policy, essentially an all-comers policy. And critically, I think in this case, Christian Legal Society stipulated to that fact. Said, yes, there's an all-comers policy. You have to accept anybody you want as a member, regardless of what their views are, even if they might, in some sense, sabotage the mission of the group, I suppose. And the question was, can they enforce that all-comers policy and deny registered student organization status to this religious group, Christian Legal Society? Justice Kennedy says yes, they can. Because what's critical for him? Is the policy neutral, right? Is it neutral? Is it the all-comers policy applying to everyone? Yes, it is. I guess they can apply it to you, right? And if you don't have an all-comers policy, if there's some people you won't let be members of the student organization, then they can deny you membership. They can deny you that RSO status. So it was a bit of surprise. Most people thought the case would come out the other way, but Justice Kennedy applying this neutrality principle, which is what drives him in all of these cases, says, no, Rosenberger is distinguishable, not least his question here is not content-based in its formulation or evident purpose. If it were to be shown otherwise, the case would likely have a different outcome. Here the policy, all comers, applies equally to all groups and views. Doesn't discriminate. That's his decision. So that's where Justice Kennedy stands on that. Well, how about in the area of aid to religious schools? Tuition aid. Who's a key vote? Justice Kennedy's a key vote. Once again, just to quickly mention a couple of cases here. What does he say about school vouchers and the like? 2002, there was a case called Zellman versus Simmons-Harris. Cleveland had a voucher program. Essentially, it gave funding for qualified students, poor students, to use this tuition aid money to go to a private school of their choice. Well, what types of schools dominate the private school world? Catholic. Overwhelmingly Catholic. There's a few Protestant, usually fundamentalist schools, maybe a fundamentalist Jewish school or a Jewish school, Orthodox Jewish school as well. It turns out, in fact, 96% of the tax dollars that went in tuition aid to these students through the vouchers went to private religious schools, predominantly Catholic schools. 96%. 4% went to non-religious schools. Just like in Kansas City, there's a Pembroke Hill and a Barstow, for example, which are private schools and not religiously affiliated. In Cleveland, there are one or two private, non-religiously affiliated schools as well, and you could use those tuition dollars potentially to get to those. So, what about that? Is that program okay? Well, first of all, I think you need to look at it in one sense. Would this program have ever been set up if most private schools were run by Unitarians? Or, agnostics? Probably not. I think that sort of the religious makeup of the schools has something to do with the fact that the voucher program was being supported by as broad a group as it was. But for Kennedy, what's the key thing here? In his decision, 5-4 case, upholding the vouchers. In sum, the Ohio program is entirely neutral with respect to religion, right? It provides benefits directly to a wide spectrum of individuals, defined only by financial need and residence in particular school district. It permits individuals to exercise genuine choice among options, public and private, secular and religious. The program is therefore one of true private choice. So for Kennedy, it wasn't the 96% that mattered, it was the 4%. As long as there's those 4% of options out there that were non-religious and the dollars can be used for them, he was okay with